I have quoted my lord, paragraph 122 and 124 of my lord, the opinion of Justice Deepak Mishra, who my lord for himself and Justice Kanvilkar in Sabarimala. May I, my lords, read that one line there and straight away go to my lords 2 paragraphs in Justice Nariman's opinion, and I'll stop at that. My lords, kindly see what Justice Deepak Mishra at 122 says in Sabarimala. In the light of the above authorities, it has to be determined whether the practice of exposing women in the age of 10 to 50 is equivalent to the doctrine of a Hindu religion, or that a practice that should be regarded as essential part of a Hindu religion, and whether the nature of Hindu religion would be altered without such explanatory practice. My lords, I come down to the wording, my lords, which says prayers and deity, and the last 3 lines in that para. In the absence of any spiritual or textual evidence, it cannot accord to the exclusionary practice followed at the Sabarimala temple the status of an essential practice of Hindu religion. My lords, please turn over. Please come straight away, my lords, to the opinion, which is, my lord, the opinion of Justice Nariman at page 18, para 176.6. My lords, in that 176.6, please permit me to read, my lords, about 10 lines very quickly. It is only the essential parts of a religion as distinguished from secular activities that is the subject matter of the fundamental right. Superstitious belief which are extraneous and unnecessary accretions to the religion cannot be considered as essential parts of the religion. Matters that are essential to religious faith and or the belief are to be judged on the evidence before a court of law by what the community professing the religion itself has to say as to the essentiality of the belief. One test evolved would be to remove the particular belief stated to be an essential belief from the religion. Would the religion be the same or would it be altered? Equally, different groups of religious communities speak with different voices on the essentiality aspects presented before court. The court is then to decide as to whether such activity is or is not essential. Religious activities may also be mixed up with secular activities, in which case the dominant nature of the activity test is to be applied. I stop there, man. If we say that a child who wears a hijab is prevented to wear a hijab into school, question is, would it alter the religion or would the religion remain the same? The sequitur is this. Does this mean that all the other 95% of the Muslim children who are not wearing hijab to a school, they are not professors or practitioners of Islam? Has the essence of Islam changed by a lady wearing or not wearing hijab? Akin to Hindu faith, if I don't actually wear my lords a tilak, or if I don't wear my lords a saffron attire when I go to pray, if I go to a temple, my lords, in a denim jeans and a t-shirt to pray, is the essence of Hindu religion lost? My conscience is Hindu, I profess Hindu faith, but my attire, my lords, is just a manifestation. Please come to 285, my lord. Next para is of utmost importance. And my lord, this 285 is Justice Chandrachud's opinion, my lord. And I read that, my lord. It went through an editorial correction. I put that as well and I read it. My lord, 285. In this jurisprudence of religious freedom, this court has evolved a body of principles which define the freedom of religion under Article 25 and 26 to practice, quote unquote, essential to religion. The Constitution has to protect not only freedom of religious belief, but acts done in pursuance of those beliefs. While the views of religious denominations are to be taken into consideration in determining whether a practice is essential, those views are not determinative in its essentiality. Kindly note that. The court has a central role in determining what is or what is not essential to religious belief. Intrinsic to the role which the court has carved out, it has sought to distinguish between what is religious and what is secular practice, even if it is associated with religious activity. Going further, the court has inquired into whether a practice is essential to religion. Essentiality of a practice would, as the court has held, depend on whether the fundamental character of a religion would be altered if it were not observed. Above all, emphasis on constitutional legitimacy. Kindly note this, my lords. Above all, there is an emphasis on constitutional legitimacy, which underscores the need to preserve the basic constitutional values associated with the dignity of the individual. My lords, I stop there. The basic constitutional value for me as a school is, I have to impart secular education in my school. I have to, my lords, under 39J, ensure that dignity of the girl child is protected. I will not, my lords, prescribe a protective attire to a girl child and no protective attire to a boy child. Why? On the religious faith, to saying that girl must dress modestly and a boy need. My lords, for a minute, please permit me to dilate on this. When religion, my lords, was formed and these embodiments came in, my lords, in our holy texts, whether it is the Quran, whether it is the Bible, or, my lords, the Hindu religious texts, that was a time when society, my lords, might have had certain requirements to maintain community standards. Maybe at that point of time, women had to wear a particular attire for maintaining community standards. That is, that you protect yourself from the gaze of a man, etc., etc. May have been, I don't know, I'm no expert on it. However, today, my lords, community standards are not maintained by our religious texts. Today, in a democratic polity that is India, community standards is maintained by the rule of law. If a man actually misbehaves with a woman, he should be prosecuted under the law. When the rule of law maintains community standards in a secular democratic polity, the question then I ask myself is, what is the need to have a protective attire for a female on the basis that a female should be protected from the gaze of a man and the female must dress modestly? My lords, I again ask myself the question, why is that we teach our girl child to dress modestly and not our boy child to dress modestly? Are our girls than our boys? Is that what the constitution, my lords, imposes upon us to build a society? Therefore, my lords, as a school, I have the obligation to ensure that I gradually go towards a gender neutral uniform. Not even to say salwar kameez for girls and pant and shirt for boys. Certainly not to say that girls must therefore protect themselves with a headgear. In that light, I have an obligation, my lords, an argument was raised before your lordships, my lords, in the connected petition by my esteemed friend, Mr. Kamar. Once it is a matter of faith, nobody should go into it. It is the person's faith that should be protected. Your lordships also should not go into it to take a decision on whether it is essential or not essential. With utmost respect, the law is marched. My lords, after pre-Shirur Mat, my lords, whatever may have been the law, after Shirur Mat, after Venkataramana Devaru, after Saifuddin Saiba, my lords, that is the Mori Muslim excommunication case, and my lords, now Shabrimala, the law is, court is central to taking a decision that it is essential or not essential. It is not left, my lords, to the private person. And that can be done only by evidence that is being brought in court. If my learned friends had filed a civil suit, my lords, and brought in evidence, it's a different matter. No, not even a single affidavit, my lords, brought in to indicate whether it is essential or not essential, except to quote, my lords, one or two paragraphs of the Quran. Therefore, my lords, the fact that burden is, my lords, not discharged, kindly see, my lord, the last three lines, my lords, of Justice Chandrachud's opinion at 285. Apart to, my lords, character of a religion, etc., fundamental character of religion being altered, they say, above all, constitutional legitimacy is the question. In a constitutional legitimacy situation, can we dress our girls differently to say, no, you have to dress modestly? Where is this concept of modesty for a girl child coming from when there is no school uniform of modesty for a boy child? Well, in that light, I'm conscious that I have gone beyond 3:45. Would your lordships give me 1 minute, my lords, on the justification? Please come to page 20, my lords. My lords, in page 20, please come to, my lords, page 20, para 23. Free speech consideration. I will not read it, but please, my lords, note 373 of Puttaswamy. In 373 of Puttaswamy, the question came up on, will religious appearances be a part of personal autonomy and therefore a 19(1)(a) and a 21 right as right to privacy? That was also pitched before your lordships. I have personal autonomy. I should be allowed to wear what I should. My lords, in 373, their lordships say, the choice of appearance and apparel also aspects of the right to privacy. But continue, please continue. The freedom of certain groups of subjects to determine their appearance and apparel, such as keeping of long hair and wearing a turban, in this case, Hijab, are protected not as part of a right to privacy, but as part of their religious belief. Therefore, this protection applies to them under 25(1), which is subject to 25(2). And therefore, my lords, we can by saying everything is put under 19, everything is put under 21. Freedom of conscience is also 21 minutes. How can I be a full-fledged individual and not have a right to life if I don't have a freedom of conscience? But freedom of conscience is 25. It is subject to other parts of Part 3. It is subject to 25(2), which is subject to, my lords, building an egalitarian, social, secular order in the country. And that is important. That's why I brought Bommai, saying maintaining a secular order is the paramount obligation, my lords, of the state, or for that matter, educational institution. And when it comes to education institution, I must be given the latitude, my lords, to prescribe my uniform. My lords, last thing is G, my lords, at 21. This is, my lords, the justification pattern. My lords, Regina versus Denbigh was brought in, my lords, that is the House of Lords decision. I will not read it, but I will only trouble your lordships at your lordships, which are kindly see the paragraphs. The question, my lords, which Baroness Hale brings out is this. My lords, in para 96, Baroness Hale brings out. May I, my lords, would your lordships permit me in 3 minutes, my lords, read 96, 97, and I stop. My lords, kindly see what Baroness Hale says in Regina. After looking at the modicum of entire law and rights and freedom of religion. My lords, I read 96. 96 ostensibly is against it, but please see how it goes on. If a woman freely chooses to adopt a way of life for herself, it is not for others, including other women who have chosen differently, to criticize or prevent her. Yes, somebody can wear hijab, somebody can wear, my lords, the shortest of clothes, no problem. Judge so-and-so in Center versus Turkey draws an analogy with the freedom of speech. The European Court of Human Rights has never accepted that interference with the right or freedom of expression is justified by that the ideas expressed may offend someone. Correct. I can't feel it offends me, therefore don't wear hijab. Likewise, the sight of a woman in full parda may offend some people, and especially those Western feminists who believe that it is a symbol of our oppression. But that could not be a good reason for prohibiting her from wearing it. Correctly so, it is her right. But please see 97 minutes. But schools are different. Their task is to educate the young from all the many diverse families and communities in the country in accordance with the national curriculum. I have a state curriculum. This task is to help all of their pupils achieve their full potential. This includes growing up to play whatever part they choose to in society in which they are living. The school's task is to promote the ability of people of diverse races, religions, and cultures to live together in harmony. Fostering a sense of community and cohesion within the school is an important part of that. A uniform dress code can play its role in smoothing over ethnic and social divisions. But it does more than that. Like it or not, this is a society committed in principle and in law to equal freedom of men and women to choose how they will lead their lives within the law. Young girls from ethnic and cultural or religious minorities growing up here face a particularly difficult choice: how far to adopt or to distance themselves from the dominant culture. A good school will enable and support them. Stop there, Melody. A good school will support a girl child to say, I don't want to wear it. For which I have to first make sure that I instill constitutional values in them until they become a major, and then take a decision for themselves on whether they want to wear a particular attire or not. My lords, in that light, the last paragraph, my lords, I'm not reading, my lords, 98 and 99. I wish, my lords, I could have read the in para 26 50 as well, my lords. But kindly see para 27, my lords. In the light of the above, that allowing exceptions or exclusion to uniforms in the name of religious freedoms and non-discrimination is a self-defeating argument. Uniforms are mandated not with an intent to discriminate, but to prevent the very discrimination on the grounds of social, economic, and religious status. That's exactly what I need to do, my lords. To remove the discrimination, everybody wear the same thing. You may be rich, you may be poor, everybody wear the same uniform. You may be Hindu, Muslim, wear the same uniform. My lords, in that light, I will end, my lords, by introducing, my lords, para 54 of Shaira Banu. My lords, Shaira Banu is there in the Aegis compilation. In Shaira Banu, my lords, their lordships, my lord, when looking at whether this is actually a mandate in the Quran, etc., clearly, my lords, in 54 indicate there are multiple degrees of compliances that Quran indicates. Starting, my lords, from the fard, which is the first degree, to my lords, haram, which is the fifth degree. They say we can't be sitting down and saying that everything in the Quran is therefore essential religious practice. And if somebody wants to prove it, my lords, that evidence must be brought. But my submission, my lords, is one step more, and therefore I'm pitching it differently. Even assuming it is an essential religious practice, under Article 25(2), I am entitled as a school to ensure that no religious compound. And it shall not, my lords, until my school runs as a secular institution, imparting public instructions, that too, my lords, with the aid and finance of the state. I am obligated, not just I have a higher order, I am obligated under the constitution to ensure that no religious symbol enters my school compound. My lords, with that, my lords, I rest my case. I am very, very grateful for the patient hearing.
Thank you. Continue tomorrow. Represent whom? Who is respondent number 8?
Yaru. Respondent number 8. Who?
Who is respondent number 8?
Describe. Teacher, student, college. Huh?
What more is to be argued on behalf of the teachers? Mr.
And he needs only 15 minutes time. He has a very different point which has to be put before this not put. 15 minutes time is that we request.
All right.
Some time for rejoinder, my lord. We have heard very erudite, my lord's arguments. My learned friend, my lords, I need some time to rejoin, my lord. Tomorrow, my lord.
You will get your time.
Lords, after the rejoinder, my lords may consider interveners, my lords, only requesting. We can just get a few minutes, my lords.
I will request all the interveners to make your written submission and submit it to the court.
My lords may just give us 10 minutes. I won't take
No, we don't need any assistance of the interveners, but since so many of intervener applications have come, so we don't want to disappoint you all. We say that whatever you want to say it in writing, prepare your written submission and submit it, we will consider it.
The only reason I was mentioning, my lords, even no one has made the argument of sex discrimination.
We cannot continue hearing this matter for 6 months.
Only 10 minutes, my lords. I'm
If you
requesting
people want that, we will not have this bench every day.
only a request, my lords. I leave it to my lords. 10 minutes if we get, I would be.
Not possible. We have to dismantle the regular benches and then special benches to be constituted. And every day we are hearing these matters. So we want you all to be very brief in your submissions and finish your arguments as early as possible.
Places, my lord. I'm in student number 303.
In Karnataka named Harsha because
Who are you?
Right of rejoinder. 3038, my lord. I'm arguing for the petitioners, my lord.
Somebody else is making a mention, Mr. Yusuf. So,
I am moving this intervention because.
no, we are not hearing any intervention application. We have made it very clear from the beginning.
Kindly hear me for 30
No,
seconds.
sorry, you cannot insist. You have no right to be heard unless we call upon you.
A man has been killed 2 days back because people do not understand whether it is a religious practice or not, whether it is an essential religious practice or
Go
not.
and initiate the criminal proceedings.
No, there is already going on, but then people are fighting on roads.
This is not the matter in which we have to consider all that.
In respect of two petition, Lordship, there is only we are seeking some clarification. There is a degree college student.
What can be done? You are seeing it. We are not getting any time to consider your application.
Several problems. No, in fact, I must, from if Lordship permit me, in both the petitions my learned friend has filed. In fact, my learned friend himself has filed one more petition with reference to the same institution. The matter came up before the learned single. The learned single judge has already passed an order that the interim order passed by the full bench will also apply to all these institutions. Matter rests there. The question of not again coming up before your lordship with another student of the same institution is nothing but vexatious. Lordship, my humble submission is same count. Already order has been passed.
Your lordship places, my lord.
That clarifies the position. Where is the question?
I make my submission, Lordship. I have already pointed out that aspect. Even that interim order also I presented. The order of this court very clearly stated that in para number 11, it is only confined to those schools that a CDC is there. But that is a degree college student, and this particular order does not apply. Even the interim order was passed. There is no clarity. For that reason, I moved this petition for seeking clarification of that order.
All
That is
right.
only a limited
All right.
prayer I am making.
Wait.
I have not kept anything in dark. I bought all the fractions because even I bought the.
Wait for your turn. Wait for your turn.
My humble submission, exams are going on, Lordship.
What
There are
is
two
it?
petitions are there. One is for a degree college, one is a private PU college. If some clarification, where some resolve, the problem will resolve, Lordship. Already department has called for the exams. They are not allowing them to go in. There is no degree college there. Degree colleges students are suffering, Lordship. For that purpose, I am just, this is not a big.
The order is very clear. We have said that wherever the uniform are prescribed, they are to be followed.
Making general.
Where there is no uniform, there is no question of
That's a difficulty, Lordship. What is citing this order? Every institutions are pushing the students outside the college, Lordship. Citing this order. For that reason, one clear word will be there from this honorable court. We have no disagreement from the order. We are saying just clarify this. I am a degree college student. Will this order be applied on me or not? That is only already during the course of argument. Learned AG has already submitted that in degree college there is no uniform is there. In spite of that, colleges are making this kind of. I do not know what my discrimination. friend is speaking, but I really, because he has now filed a writ petition in respect of Bhandarkar College. He also filed a writ petition by in respect of another student of the same institution. The institution appeared before the single judge and said that they have passed a resolution prescribing a uniform.
Then, if the uniform is prescribed,
Yes, it is prescribed. That is now-
then they have to follow it, whether it is a degree college or a pre-university college.
So far, there is no role of no uniform in any degree college. In these petitions, they came and they wanted to find. Lordship, these arrangements cannot be done immediately. They just one fine day, one institution comes and says that we are prescribing uniform, so this order will be applicable on us. The order is an interim arrangement, Lordship. Very clearly in para number 11, it is clearly been stated that even in the college itself, the rule book clearly prescribes that the girl student can wear headscarf.
How can we verify whether there is a
Lordship,
uniform? We will have to believe it on the college.
My humble submission,
Why
Lordship.
college will say that there is a
They
uniform?
are citing the order of this honorable court. This order, para number 11 is very clear. I am just asking clarification on that aspect. Because they are citing this order. Everywhere they are citing this order.
We have made it clear that wherever the uniform is prescribed, that is to be.
Kindly peruse para number 11. Lordship. Kindly peruse para number 11 of the order.
What do you want to show?
We make it clear that order is confined to such institution where the college development committee has prescribed the school dress code uniform.
Yes.
This is college development committee in respect of government PU colleges.
No.
There is only government PU college, only
Because that was the petitioner's college.
All that I would submit, Lord, if somebody has violated this order, but he has to bring it before your lordship, calling into question that order. This kind of allegation without any some clarification will be made from the past clarification. If somebody has there are two private institutions.
We are making it very clear that wherever, whether it is a degree college or a government college, undergraduate, if the uniform has been prescribed,
Yes.
then that has to be followed.
It is not there.
So long as the matter is pending before the court.
This is not there. This is not the instance of this order. Para number 11 clearly says that college development committee, and there was a discussion of the legality of the college development committee also.
This is what now you want clarification. We have made it clear.
It will create a choice in the society, Lord.
No,
because everybody is quoting this order and they are pressing their own rules, Lordship.
Yes, tomorrow too.
Lordship, please, Lord, may I just say, Lordship indulgence, Lord.
But some hearing is required.
We cannot hear so many people at the time.
But some hearing and these two petitions, this hearing is required, Lord.
The teachers are not only the teachers are forced to be remove their headscarf and forced to be remove their burqa and also after before entering the college.
Do it.
Teachers, we are
creating a discrimination in the society.
The order is with respect to students. The order confines to students only.
I would request this kind of statements cannot be
All right, thank you very much.
explanation.
Tomorrow at 2:30, the arguments of Mr. Naganan, the Council for Respondent Social has concluded. Mr. Silent Korea has also concluded his arguments along with Mr. Raghavan Srivas for respondent number so and so. It is informed that counsel for respondent number 8 has to make his submissions put up tomorrow at 2:30.
Then, Mr. President, may I say one thing?
To degree colleges,
What advises, my lord?
this order, my lord, this order will not apply to degree colleges, even the degree